Hello everyone, I am Shrikant, an associate at GLA, and in this video I will be discussing about the rights, duties and obligations of entities and other parties involved in the processing and handling of children's data. I find this a very relevant and timely topic considering that the UK's privacy regulator, that is the Information Commissioner's Office, has recently published a code of conduct which is currently awaiting parliamentary approval, which sets out standards that entities processing and handling children's data need to follow. Some of the obligations in this code of conduct include A. Location settings that would allow a child's location to be shared with any third party should be disabled by default, and B. The privacy settings should be set at the highest standard by default. So let's dig into this topic a little deeper. Currently, the only regulation in India on data privacy is the Information Technology Reasonable Security Practices and Procedures on Sensitive Personal Information Rules 2011, or more commonly referred to as the SPI rules. Now, the SPI rules really don't contain anything or make a special provision for handling and processing children's data. However, this is all set to change with the proposed Personal Data Protection Bill, which has some additional clauses on children's data and places additional obligations on entities that handle and process children's data. There seems to be no global consensus as to the definition of a child with respect to data privacy, with some countries prescribing an age lesser than that of 18. In the US, for instance, the Children's Online Privacy Protection Act 1998, or more commonly referred to as COPPA, treats anyone below the age of 13 as a child. On the other hand, the European Union's General Data Protection Regulations, or more commonly referred to as GDPR, has taken a stance that anyone below the age of 16 will be treated as a child. However, it does make an exception that member states of the EU can prescribe that anyone below the age of 13 be treated as a child with respect to GDPR. The proposed PDP bill in India, however, has taken a completely different turn as compared to COPPA and GDPR and prescribes that anyone below the age of 18 to be treated as a child. The primary obligation stipulated under the PDP bill for handling children's data is that the data fiduciary or the data controller, for GDPR parlance, should A. obtain the consent of the parent or guardian, and 2. verify the age of the child. One point to note is that while both GDPR and the PDP bill require that data fiduciaries or data controllers obtain parental or guardian consent, GDPR merely stipulates that the data fiduciary or the data controller verify that the person giving consent on behalf of the child is actually the child's parent or guardian. However, the PDP bill goes a step further and obligates or places an obligation on data fiduciaries or controllers to verify the age of the child itself. However, the main question is how can entities verify the age of the child? Now, although this might seem like a simple proposition, it can get pretty tricky. It won't be sufficient if entities just get the date of birth of the child. They will also need to verify the same. Although the most straightforward method to verify the age of the child might be to require the child to upload a government issued ID, this poses different data privacy issues in itself. However, there are new techniques that are being introduced, such as entities requiring people to answer certain questions which in all probability only an adult will know and a child won't. Or there are some solutions whereby they require the party to upload a photo, or even some that require a party to share their credit card numbers. Now, these all pose challenges in themselves, and till now there is no universally accepted method that is used by the industry to verify age. However, you never know, the Data Protection Authority that will be established by the PDP bill might come up with new rules as to how entities can go about verifying age. Although we have spoken about the obligation of data fiduciaries to obtain parental consent before processing or handling children's data, the PDP bill has made certain exceptions under which parental or guardian consent will not be necessary. A few of these scenarios are: A, if the entity is exclusively providing children's counseling or child support services; B, if the information will be processed for the purpose of law and order enforcement; and C, if the information is being processed for the exercise of a judicial function. Under GDPR, once a parent or a guardian has given consent to process their children's data, the data controller can move ahead and process their data in accordance with their terms of service. While the PDP also provides for the same, it has made a carve out and has created a new class of entities which will have further restrictions imposed on them with regards to handling and processing children's data. Now the question arises as to who these restricted entities are. Now the Data Protection Authority will actually classify these entities taking into consideration entities that A, operate commercial websites directed at children, or B, process large volumes of personal data of children. Such entities have been termed as guardian data fiduciaries. Under the PDP bill, a guardian data fiduciary has been barred from profiling children, tracking children's data, monitoring the behavior of children, placing targeted ads at children, and undertaking any other activity that can significantly harm the interests of the child. On comparing GDPR and the PDP bill, we can confidently say that the PDP bill has taken a lot of proactive steps in order to protect the interests of the child. However, we feel that there are a few small steps that can be taken in India to further protect the interests of the child. One such step is to introduce verification to ensure that the person giving consent on behalf of the child is actually the parent or the guardian of the child. Now, this is a concept that has been incorporated under GDPR. So, therefore, like GDPR, the PDP bill can mandate entities to do a minimum due diligence to ensure that the person giving consent on behalf of the child is actually the child's parent or guardian. Now, companies like Microsoft have already started implementing this. They require parents to either A, share their credit card details, or B, share their e-signature, or C, use their IPIN to log on to Microsoft servers. Now, another step is just like the UK, the Data Protection Authority should come up with additional code of conduct that entities will need to follow whilst handling children's data in India. This is clearly going to be a huge area of focus going forward, considering the sheer number of services being created targeting children. Startups today consider children as a separate demographic while creating goods and services. Therefore, we truly hope that the Data Protection Authority strictly monitors entities processing children's data and enforces the obligations mentioned under the PDP bill. I truly hope you found this video interesting, and please do share your feedback on this video. Thank you.